Imagine it is a Tuesday morning. You're a university administrator.
Right?
Maybe you're the dean of students at, a mid-sized liberal arts college somewhere.
Okay.
You sit down at your desk, you open your email, and sitting right there in your inbox is a 120-page legal injunction from a federal court in a state that is like hundreds of miles away.
Oh, wow.
Yeah. And with the stroke of a judge's pen, the entire rule book governing how your university handles one of the absolute most sensitive high-stakes issues on campus, which is sexual misconduct, has just been thrown out entirely.
Gone overnight.
Exactly. You are suddenly ordered to revert back to a completely different set of rules that were drafted years ago by a totally different political administration.
Rules that you probably spent, thousands of hours and millions of dollars unwinding in the first place.
Right. So how do you explain that to the freshman who just walked into your office looking for help? Or, how do you explain that to the accused student who is currently facing expulsion?
You really can't.
Yeah.
It is a state of just permanent administrative whiplash.
Yeah.
And to understand how American higher education arrived at this specific point of legal chaos, you really have to look backward. You have to trace a line all the way back to 1972.
Okay.
To a piece of legislation that, remarkably, was never originally written to address this specific problem at all.
And that is exactly the core mystery we are unpacking today on this deep dive. We are looking at a single sentence, just 37 words written into the Education Amendments of 1972.
Which most people just know as Title IX.
Right, Title IX. And if you actually read those 37 words, you will not find the word assault. And you certainly won't find the word rape.
No, you won't.
And yet somehow that single silent sentence became the United States' primary overriding legal tool for confronting sexual violence on college campuses.
It's an incredible evolution. What we have in our sources today is just a massive stack of material tracking exactly how that happened. We're going to trace how those 37 words were transformed by brilliant legal theorists and then molded by the Supreme Court, and then aggressively leveraged and continually rewritten over and over by the executive branch. We've got foundational Supreme Court opinions spanning decades, federal guidance documents from multiple administrations, and historical analyses from both civil liberties organizations and women's rights groups.
Which brings up a really important point. I want to pause and say this right up front, because our sources today track how drastically different political administrations handled this, specifically the Obama, Trump, and Biden administrations. I want to be absolutely clear to everyone listening. We are not taking sides here.
Right, definitely not.
We are not endorsing any specific political viewpoint, and we are not here to play political referee. We are just impartially reporting on the factual history, the legal arguments, and the administrative policies exactly as they are detailed in our source dossier.
Our goal is really to dissect the legal architecture, not to advocate for a specific outcome. And that requires setting a very specific, measured tone for this deep dive. We're approaching this with a documentary-style lens. This is not like a debate to be won.
Right.
We're attempting to provide a really careful accounting of how meaning was built into a law over half a century and how institutions are currently struggling with this incredibly difficult tension between protecting victims of sexual violence and ensuring robust due process for the accused.
So let's go back to the beginning, the blank slate. Because the original text of Title IX was designed to basically bar sex discrimination in schools that receive federal funding.
Right.
The text essentially says, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance.
That's the whole thing.
That's it. It meant a university couldn't refuse to admit women, or they couldn't vastly underfund the women's athletic programs. But it was completely 100% silent on sexual harassment.
It was entirely silent. Because, in the early 1970s, the concept of sexual harassment didn't even really have a firm legal definition.
Really?
Yeah, it wasn't a recognized civil rights violation. If a professor made persistent, unwanted sexual advances toward a student, or if a boss propositioned a secretary.
Yeah.
The legal system, and really the broader culture at the time, largely viewed it as a personal, private misfortune.
Wow.
It was considered an interpersonal issue, maybe a disciplinary footnote if it was just particularly egregious, but it was absolutely not viewed as a structural form of sex discrimination.
Okay, so let's unpack this, because how did that leap happen? How do we go from, ensuring equal funding for the women's basketball team to using this exact same statute to adjudicate complex claims of campus sexual assault?
It's a huge jump.
It is. It feels like buying a tool designed to fix a leaky faucet, and then decades later, everyone is using it to build a skyscraper. The connection just isn't obvious.
Well, the connection actually didn't originate in education law at all. It came from the workplace.
Oh.
And it was engineered by a revolutionary legal scholar named Catherine A. McKinnon.
Right.
In 1979, McKinnon published this really groundbreaking book titled Sexual Harassment of Working Women. Before this book, judges frequently dismissed harassment lawsuits by arguing that, like, a boss who hit on a female employee wasn't discriminating against her on the basis of sex.
What were they arguing he was doing then?
They argued he was just attracted to her. They treated it as this sort of biological inevitability, or just a personal indiscretion that was completely separate from the employer's official actions.
Wait, so the early legal defense was essentially he's not firing her because she's a woman. He's firing her because she turned down his date, which is a personal dispute, not a civil rights issue.
Exactly. The courts really struggled to separate the personal from the professional. McKinnon's genius was to completely reframe that whole argument.
How so?
She provided the very first sustained legal theory, arguing that sexual harassment isn't just bad behavior. It is a fundamental expression and reinforcement of women's social and economic inequality. She argued that because women were disproportionately in subordinate positions in the workforce at that time, sexual harassment functioned as a structural barrier. Therefore, it wasn't just a personal dispute, it was a systemic form of sex discrimination.
That is a massive paradigm shift. I mean, she's taking something society basically dismissed as, boys being boys or an occupational hazard, and explicitly defining it as a violation of federal civil rights law.
Absolutely. And in doing so, she identified two distinct forms of harassment that courts would eventually adopt as the standard.
And those are?
The first, she categorized as quid pro quo.
Which translates from Latin to this for that.
Yes. The direct transactional abuse of power. This is the scenario where an employee's advancement, like getting a promotion, keeping a job, getting a raise, is explicitly conditioned on sexual compliance.
Right, that's the very obvious sort of cinematic villain version of harassment.
Exactly. But the second category she defined is what we now call hostile environment harassment.
And a hostile environment is much broader, right?
Much broader.
This is where the harassment might not be tied to a specific promotion or a direct threat of being fired, but the daily environment itself becomes so permeated with severe, persistent sexual misconduct that it fundamentally alters the conditions of the person's employment.
Right.
It just makes doing the job impossible.
Precisely. Now, McKinnon initially developed this entire legal architecture for Title VII.
Title VII, okay.
Yeah, which is the section of the 1964 Civil Rights Act that deals with workplace employment discrimination. But almost simultaneously, legal activists began looking over at the college campus.
Because the dynamic is basically the same.
Exactly. I want you to imagine being a female student in the late 1970s. You were living in a world where you had practically no institutional recourse if you were harassed by a professor.
None at all.
The radical leap was taking McKinnon's Title VII workplace theory and porting it over to Title IX education law.
Which, honestly, makes perfect logical sense when you think about it from the student's perspective. The argument becomes, if a professor's harassment creates a hostile environment that forces me to drop a class, or if I am denied an A because I rejected his advances, then I am literally being denied the benefits of an education program on the basis of sex, which is exactly what the 37 words of Title IX prohibit.
That is exactly the argument. But having a brilliant legal theory is one thing. Forcing a massive entrenched institution like a university to actually listen to you and change its behavior is something entirely different.
Yeah, writing a book doesn't automatically change university policy.
Right. To do that, you have to get into a courtroom. And in the late 1970s, it wasn't even clear if a student could sue a university under Title IX.
Wait, really? Let's talk about that legal scaffolding then. Because you're right, having a right written down on a piece of paper in Washington, D.C. doesn't mean much if you, as an individual citizen, don't actually have the legal standing to enforce it.
Exactly. The text of Title IX said the federal government could pull funding from a discriminatory school. It did not say, Jane Doe can sue the university.
It's like the city writing a rule that apartment buildings must have fire escapes.
Sure.
The rule is written for the city inspectors. They're the ones supposed to enforce it by withholding a building permit.
Right.
But an implied private right of action, which is what we're talking about here, means if the building burns down, the tenants themselves can suddenly bypass the city inspectors and sue the landlord directly for breaking the code, even though the original rule wasn't written as a permission slip for tenants to sue.
That is a perfect distillation of the mechanics at play here. In 1979, we get this foundational Supreme Court ruling called Cannon v. University of Chicago.
Okay, what happened there?
Geraldine Cannon was denied admission to medical school, and she believed it was based on her sex, so she sued under Title IX. The University of Chicago's defense was essentially, look at the statute. Title IX doesn't give individuals the right to sue us.
They said only the feds can punish us.
Right? Only the federal government can police us by threatening to cut our federal funding. But in Cannon, the Supreme Court looked at Title IX, compared it to the legislative history of the Civil Rights Act, and inferred an implied private right of action.
Wow.
They ruled that Congress absolutely intended for individuals, not just sluggish federal bureaucracies, to be able to take schools to court to enforce their rights.
That shifts the power directly into the hands of the citizen. Regular people now hold the keys to enforcement.
Exactly.
And at the exact same time, the Cannon case is establishing that you can sue. Another foundational case is testing what you can sue for. Let's dive into Alexander v. Yale, because this is one of the most fascinating narratives in our source dossier.
It really is.
It was filed in 1977 and decided in 1980.
This was the first time student sexual harassment was explicitly argued as a violation of Title IX in a federal court. 5 Yale students, working directly with Catherine McKinnon and an incredibly strategic attorney named Anne E. Simon, brought the case.
And you have to remember the climate of Yale at that time.
Right.
Yale had only recently become fully coeducational. The power imbalance between the overwhelmingly male faculty and the newly integrated female student body was just profound.
The stories of these plaintiffs really highlight that imbalance. You had students alleging that professors offered higher grades in exchange for sexual favors, or that they were physically propositioned during academic meetings in private offices.
And what they were asking for in the lawsuit wasn't even money, right?
No, not at all.
They were seeking injunctive relief. They just wanted the federal court to order Yale to establish a formal grievance procedure so that students had somewhere, literally anywhere, to report this behavior.
And Anne Simon's legal strategy was to directly apply McKinnon's theory. She argued that academic advancement conditioned upon submission to sexual demands was a textbook quid pro quo violation, and it denied these women equal access to Yale's educational benefits.
And did the court buy it?
The incredible thing is, the district court judge agreed with the theory. The court officially recognized the legal principle, stating that such harassment constitutes sex discrimination in education.
But, and here's the paradox that is just deeply frustrating when you read the history, the court affirmed the monumental legal principle. But the actual plaintiffs, those 5 Yale students, lost their case.
Yes.
How does that happen? How do you prove your point to a federal judge and still lose?
It happens because of a strict constitutional doctrine called mootness.
Mootness.
Yeah. Federal courts, under Article 3 of the Constitution, are only allowed to decide active, ongoing cases or controversies. They cannot issue advisory opinions on hypothetical situations.
Okay.
By the time the appeals court made its final ruling on September 28, 1980, the students who brought the lawsuit had all graduated.
Oh, wow. So because they had originally only asked for a grievance procedure to protect them while they were active students, the court essentially said, well, you are no longer students. A grievance procedure at Yale won't help an alumnus living in New York. Therefore, your specific claim is moot.
Exactly. What's fascinating here is that they won the war of ideas, but lost the specific battle. They wedged the door open for millions of future students across the country, fundamentally changing American education law. But they themselves walked away completely empty-handed.
That is wild. But as you said, the door was officially open. The theory was validated. However, if a student wants more than just a court order forcing the school to change its policy, what if they want actual compensation for the severe harm they suffered?
Right, because an injunction doesn't pay for the therapy.
Exactly. It doesn't pay for the transferred tuition if you have to leave the school or the lost wages. This brings us to 1992 and a pivotal case called Franklin v. Gwinnett County Public Schools.
Right.
Because a right to sue means very little if the court can't actually penalize the institution financially. So what happened with Franklin?
Christine Franklin was a high school student in Georgia. and she alleged she was subjected to severe harassment and coerced intercourse by a teacher and coach on school grounds. Her case went all the way to the Supreme Court.
And what was the core question they were deciding?
The question was simple. Can a student who is intentionally subjected to sexual harassment under Title IX recover monetary damages from the school district?
And what did they say?
In a unanimous 9-0 decision, the Supreme Court said yes. They relied on this long-standing legal presumption that where there is a legal right, there is a legal remedy. Unless Congress explicitly says otherwise, federal courts can award any appropriate relief, including money.
So the landscape shifts entirely in 1992. The theory is established, the right to sue is established, and the threat of massive financial damages is established.
Yes. Schools across the country suddenly realize this is no longer just a public relations issue or a minor disciplinary headache. This is a catastrophic financial liability.
Which immediately sets up the next high-stakes legal battle. Because if a school can be sued for monetary damages, when exactly is the entire institution held liable?
That's the million-dollar question, literally.
Right. If one rogue teacher commits an assault, or if two students have a horrific encounter in a dorm room on a Friday night, is the university's massive endowment automatically on the hook?
The Supreme Court grappled with this exact tension in two twin cases in the late 1990s, and they established an incredibly strict, very high bar for institutional liability.
Let's walk through those.
The first was Gebser v. Lago Vista Independent School District in 1998, which dealt with a teacher harassing a student. The court ruled that a school district is only liable for damages if an official who has the authority to institute corrective measures had actual knowledge of the harassment.
Actual knowledge.
Yes, and they had to have responded with deliberate indifference.
Okay, let's break that down because those are very specific legal terms of art. Actual knowledge means the victim or someone else had to explicitly report it to someone in power, right?
Correct. The school cannot be sued just because they should have known or because there were rumors going around the locker room.
Right. And deliberate indifference means the school official essentially shrugged their shoulders and did absolutely nothing. Or their response was so unreasonably weak, it was basically a green light for the harassment to continue.
That is exactly right. It is a very steep hill to climb for a plaintiff. And then a year later, in 1999, the court extended that same strict framework to peer-on-peer harassment.
Yeah.
So student-on-student harassment.
This was Davis v. Monroe County Board of Education.
Yes. The Davis standard said a school is only liable for peer harassment if they have actual knowledge, act with deliberate indifference, and the conduct itself must be so severe, pervasive, and objectively offensive that it effectively denies the victim access to their education.
Severe, pervasive, and objectively offensive. So if a college student wants to sue their university for money because they were harassed by a classmate, they have to prove three incredibly difficult things. The university officially knew. The university's response was essentially to ignore it, and the harassment hit that severe and pervasive threshold.
Yes.
Let me play devil's advocate here for a second. Why did the Supreme Court set the bar so astronomically high? Doesn't that just let universities off the hook for a vast majority of the day-to-day harassment students face?
It absolutely does insulate the universities. But you have to understand, that was intentional.
Intentional.
Yes, you have to look at the legal philosophy behind the ruling. The majority of the court, particularly the conservative wing at the time, was deeply wary of opening the floodgates to endless federal litigation against schools for every bad interaction, crude joke, or dating dispute between teenagers.
I see.
Furthermore, they noted that Title IX is fundamentally a spending clause statute.
Okay.
It's basically a contract between the federal government and the school. The school agrees not to discriminate in exchange for federal funding.
Right.
The court reasoned that you can't punish the school financially unless the school intentionally breached that contract by knowingly ignoring severe harm. They didn't want federal courts micromanaging middle school cafeterias and college dorms.
Okay, I understand the legal logic,
Okay.
but the tension here is massive. That high legal bar protects the school's bank account, but it creates a massive gap for the victims.
It creates a huge gap.
What happens to the student whose harassment might not meet the strict legal definition of severe and pervasive, but is absolutely ruining their ability to feel safe on campus? The gap between what it takes to win a $1 million lawsuit in federal court and what it takes to actually manage the day-to-day safety of students on a campus is a chasm.
And that chasm is exactly what sets the stage for the modern era of Title IX, because in the 2010s, The focus shifts away from the slow, deliberate crawl of the judicial branch, where plaintiffs are trying to win monetary damages, and moves entirely into the fast, aggressive, and sweeping power of the executive branch.
We are entering the era of federal guidance. We are jumping into the 2011 earthquake.
Yes, we are.
Because lawsuits are about looking backward at a failure. But how a school manages a complaint on a random Tuesday, how they build their internal rulebooks, that is administrative. On April 4th, 2011, under the Obama administration, the Department of Education's Office for Civil Rights issued a document.
A very famous document.
Yes, a 19-page Dear Colleague letter authored by Assistant Secretary Ruslan Ali. Here's where it gets really interesting.
It is nearly impossible to overstate the impact of those 19 pages. They completely rewired the daily operations of higher education in America.
And the mechanism here is fascinating to me, because this letter didn't invent a new law, right? It didn't go through Congress. It was technically just a statement of how the executive branch interpreted the existing 37 words of Title IX, but it was read by universities as an absolute mandate, because the implied threat was, follow these 19 pages or we will strip your university of all federal funding.
Which would instantly bankrupt almost any university in the country.
Exactly. So let's dissect exactly what this 2011 letter demanded, because it fundamentally altered the procedural rights of everyone on campus.
First, it directed schools to actively investigate and adjudicate sexual harassment and assault complaints. They could no longer passively wait for a police report. They had an independent obligation to act.
Okay.
Second, and by far the most controversial, it mandated that universities use the preponderance of the evidence standard when deciding if an accused student was responsible.
Okay, let me stop you right there. Preponderance of the evidence. If you put the evidence on a scale, it just has to tip a microscopic fraction like 50.1% to 49.9% to find someone responsible.
Right.
It literally just means more likely than not. If the consequences of a guilty finding on campus are a permanent expulsion, a ruined academic transcript, and a brand of sexual assailant that follows you for life. How did the Department of Education justify forcing universities to use the absolute lowest standard of proof in the American legal system?
The Office for Civil Rights rationale was rooted in civil rights parity. They argued that Title IX is a civil rights statute, not a criminal code.
Okay.
In civil rights lawsuits, like an employee suing a company for racial discrimination, the preponderance standard is the norm. The argument was that if you use a higher standard, like clear and convincing evidence, you are inherently valuing the accused's right to stay in school more than the victim's right to an education free from harassment.
Ah, I see.
The 2011 letter argued that a 50.1% standard treats the educational rights of both parties equally.
But the mandates didn't stop there. The letter also urged prompt timelines, suggesting universities should aim to resolve investigations in 60 days. It required schools to allow complainants to appeal if the school found the accused not responsible, which, if you think about it, is essentially allowing double jeopardy in the campus context.
Yes.
And crucially, it strongly discouraged direct cross-examination of the accuser by the accused, arguing it could be highly traumatizing.
When you look at the immediate aftermath of this guidance, you see two completely divergent realities emerge on American campuses. Two distinct narratives that our sources document extensively, and we have to hold both of them fairly.
Let's look at the first reality, the monumental victory for survivor advocates. For generations, as we saw with the Yale case, sexual violence was swept under the rug. It was dismissed as a private misfortune. Advocates rightly point out that this 2011 letter finally forced the hand of these massive, sluggish institutions.
They absolutely did.
Campuses across the country suddenly poured resources into robust Title IX offices. They hired dedicated coordinators. They began treating complaints of sexual violence with the gravity of a federal civil rights issue rather than a minor disciplinary nuisance. For thousands of victims, it was the first time an institution actually validated their harm and took action.
It was a necessary corrective to decades of institutional indifference. That is undeniably true. But then you have the other reality.
The backlash.
The intense procedural backlash. This brings in civil liberties groups, most notably FIRE, the Foundation for Individual Rights and Expression, as well as many legal scholars and law professors. They looked at the mandates in this letter and saw a complete stripping of due process protections for accused students, who, the data consistently shows, are disproportionately male.
Right. The argument from critics was multifaceted. First, there was an administrative complaint. The Department of Education bypassed the formal rulemaking process. The Administrative Procedure Act usually requires agencies to post proposed rules, allow months of public notice and comment, and then formally address those comments. The Obama administration bypassed all of that by calling it a guidance letter and started enforcing it immediately.
And practically, the critics argue that the specific combination of procedures created a system heavily biased against the accused. If you combine the lowest standard of proof, that 50.1%,
Yeah.
with a single investigator model, where one university employee acts as detective, prosecutor, judge, and jury.
Which happens on a lot of campuses.
Right. And you remove the right of the accused to cross-examine the evidence against them. Civil libertarians argued you have basically constructed a kangaroo court.
To put a metric on that backlash, our sources note a staggering statistic. Following this 2011 guidance, there were more than 600 lawsuits filed by accused individuals against their universities.
That's hundreds.
600 students taking their schools to federal court, alleging they were expelled or suspended through truncated, biased proceedings that denied them basic fairness.
And this reveals the inherent fragility of the 2011 earthquake. Because it was built on an agency's guidance letter, and not a formal legislative act by Congress or a robust regulatory rule, it was entirely dependent on the political administration in power.
Which brings us to the administrative whiplash. What happens when a policy built on an agency-specific interpretation meets a brand new president with a completely different legal and political philosophy?
You get the DeVos era. In September 2017, the Trump administration's Secretary of Education, Betsy DeVos, formally rescinded the 2011 Dear Colleague letter. She explicitly cited the mounting due process concerns and the massive wave of lawsuits from accused students as the justification.
But just deleting a guidance document leaves universities in a vacuum.
Exactly. So the department embarked on the long, formal, multi-year process of creating binding federal regulations through the Administrative Procedure Act.
Going through all the formal notice and comment that the previous administration skipped.
Yes. And in May 2020, those regulations finally dropped, and they essentially took the Obama-era guidance and flipped it on its head.
Let's detail these massive changes because they directly dictated exactly how a student reported an assault and how a student defended themselves on every single campus in the country. Let's start with the definition of harassment itself.
The 2020 rules significantly narrowed the definition of actionable sexual harassment. Instead of the broader definitions used previously, the DeVos rules reached all the way back to that 1999 Supreme Court case.
Davis v. Monroe.
Yes. They mandated that to be considered Title IX sexual harassment, the conduct had to be severe, pervasive, and objectively offensive.
This is a crucial shift. They took the incredibly strict standard required to sue a school for millions of dollars in federal court, and they made it the threshold for the school's own internal disciplinary process.
Right.
If a student's experience didn't meet all three of those adjectives, severe, pervasive, and objectively offensive, the Title IX office was legally required to dismiss the formal complaint.
They also mandated a presumption of innocence. The accused must be presumed not responsible until a formal finding is made at the end of the process. They allowed schools to choose whether to use the preponderance standard or the higher, clear, and convincing standard. But the most controversial, explosive change was about the structure of the hearings themselves.
Right. The 2020 regulations mandated live hearings with cross-examination, and not just any cross-examination. It had to be conducted by each party's chosen advisor. The students couldn't directly question each other, but their representatives could. This sets up a profound philosophical and practical trade-off. Let me ask you about this. Because from a strictly legal perspective, cross-examination is considered the greatest legal engine ever invented for the discovery of truth.
It is the bedrock of the American legal system.
Right. If someone is facing expulsion and a life-altering brand, their advocate absolutely should be able to aggressively question the credibility of the evidence against them.
That is the core due process argument. You cannot find the truth in a he said, she said scenario without testing the stories under pressure.
But on the other hand, isn't the greatest engine for truth also an incredibly effective engine for intimidation in the specific context of sexual assault?
It can be, absolutely.
If you have been traumatized, the thought of sitting in a room and being aggressively grilled by the accused representative, maybe an expensive lawyer they hired, sounds terrifying. Doesn't mandating a live cross-examination suppress reporting?
This is perhaps the most fiercely contested open question in the entire Title IX debate. Reasonable, deeply well-intentioned observers fundamentally disagree on this.
I can see why.
Defenders of the 2020 rules argue that cross-examination is just basic American fairness. You cannot sacrifice truth-seeking just because the process is uncomfortable.
Right.
But advocates for survivors counter that applying courtroom-style adversarial tactics in a college setting inevitably re-traumatizes complainants and creates a huge chilling effect on victims coming forward. And as our sources carefully note, the empirical statistical evidence on exactly how these specific hearing procedures affect overall reporting rates over time, it's not firmly established. It is a debate rooted in profound competing values.
And just as universities spent years and millions of dollars completely rewriting their faculty handbooks and student codes of conduct to comply with the 2020 regulations, the administration changed again.
Of course it did.
Enter the Biden administration in 2024. They issue their own massive set of rules. They attempt to broaden the definition of harassment back out, moving away from the strict Davis standard so schools can intervene earlier.
Right.
They remove the absolute mandate for live hearings. But they also did something monumental. They explicitly extended Title IX protections to cover gender identity and sexual orientation.
Which was a massive policy shift intending to protect a highly vulnerable student population. But, as with everything in this 50-year legal saga, the law is never settled.
Never.
We have to introduce the latest plot twist from our sources. On January 9, 2025, a federal court in Kentucky, the U.S. District Court for the Eastern District of Kentucky, in a case called Tennessee v. Cardona, issued a ruling that brought the entire system to a screeching halt. The judge vacated the 2024 Biden rules nationwide.
Nationwide, meaning with one ruling, the new rules were completely struck down across the entire country. Why? On what legal grounds?
The court held that the Department of Education exceeded its statutory authority. The judge ruled that the department, as an executive agency, did not have the constitutional power to unilaterally redefine those original 37 words from 1972, specifically the phrase "on the basis of sex," to include gender identity without a formal act of Congress.
So with the stroke of a judge's pen in January 2025, the 2024 rules vanish into thin air. And what happens next? The 2020 DeVos-era rules immediately spring back into force.
Stuff like that.
Which brings us back to the administrator at their desk on a Tuesday morning. I want everyone listening to really absorb this reality. Imagine being a college freshman or a university Title IX investigator trying to navigate this landscape.
That's a nightmare.
The rules governing how you report the most traumatic event of your life, or the rules governing how you defend yourself against a life-ruining accusation, they swing wildly depending on the year, depending on who is in the White House, and depending on sudden federal court injunctions. You are living in a state of permanent legal whiplash.
It is absolute administrative chaos. And taking a step back from the timeline, from McKinnon's theory to the Dear Colleague letter to DeVos to Biden to the Kentucky injunction, we have to look at the structural root of this entire decades-long controversy.
Okay, let's look at the structure.
Because the whiplash isn't just about changing political priorities in Washington. It is about a fundamental, foundational, structural mismatch.
You mean the fact that a college campus is not and has never been a courtroom?
Exactly. We are continually asking university disciplinary systems to perform a judicial function they were never designed, equipped, or funded to perform.
Let's just list what a campus tribunal lacks compared to an actual court of law.
Go for it.
They have no juries of impartial peers. They are usually panels made up of, like, an English professor, a housing director, and an assistant dean who took a weekend training course.
Right.
They have no strict rules of evidence. Hearsay, which would be thrown out of a real court instantly, is often perfectly acceptable. They have absolutely no subpoena power. A university dean cannot compel a reluctant witness to testify.
They cannot compel a local bar to hand over security footage. They cannot execute a search warrant on a student's cell phone to get text messages. And they have nowhere near the investigative resources, the forensic labs, or the trained detectives of the criminal justice system.
And on top of all of that, they operate without the ultimate backstop of a real court, which is the penalty of perjury. If a student lies to a campus investigator, they might face a conduct violation, sure, but they aren't going to prison for perjury.
And yet, look at the staggering burden we place on these campus administrators. It's almost absurd when you really break it down.
Yeah.
We are asking a hired Title IX coordinator to resolve some of the gravest, most fiercely contested, legally complex, and life-altering allegations a human being can face.
An expulsion for sexual assault permanently alters the trajectory of a young person's life. It destroys their career prospects and their reputation. Conversely, forcing a victim to remain in the same dorm or the same classroom with their unpunished abuser permanently alters their life and their mental health. The stakes are unimaginably high, and the tools provided to the universities to figure out the truth are just incredibly weak.
Synthesizing all of this, we can see that every single administration's rules, the Obama guidance demanding proactive speed, the Trump regulations demanding rigid courtroom-style due process, the Biden rules attempting a middle ground, they all represented a different, inherently flawed answer to an unanswerable question.
Right.
How do you perfectly balance fairness to a complainant who has suffered severe trauma and fairness to a respondent facing life-ruining consequences inside an academic institution that was built to grade history essays and organize intramural sports, not to deliver formal judicial justice?
It is the impossible task. And that brings us to the end of this deep dive into the sources. We started with 37 silent words in a 1972 funding statute, words that never mentioned harassment. We watched Catherine McKinnon theorize a brilliant connection between workplace power and sex discrimination. We watched the Supreme Court build the scaffolding through Cannon, Alexander v. Yale, Franklin, and the high liability bars of Gebser and Davis. And we watched the modern whiplash of federal guidance and nationwide injunctions turn college campuses into a volatile legal battleground.
It is a profound evolution of law driven by dedicated activists, tested by staunch civil libertarians, and constantly revised by the courts.
And the reason this matters to you, why we spent this time dissecting the legal mechanics, is because this isn't abstract legal history trapped in a textbook somewhere. This dictates the daily reality of justice, fairness, and safety for millions of students navigating American campuses right now. Every time the rules change, every time an injunction is handed down, real lives, real educations, and real futures are directly impacted.
Which leads us with a final provocative thought.
Yeah.
We have seen the massive gap between the strict, deliberate indifference standard required to actually sue a school in court and the proactive, aggressive, constantly shifting enforcement demanded by different federal agencies.
Right, the chasm we talked about.
Exactly. If that gap is never truly reconciled, is it possible that our educational institutions are trapped in a system where achieving true, unassailable fairness for both sides is fundamentally impossible?
Can the broken X-ray machine ever be fixed if it was never designed to take the picture in the first place? That is something to mull over. Keep questioning, keep exploring, and we will catch you on the next deep dive into the sources.